1 for November. My name is Alina Gilbert. I will be conducting the webinar today. So thank you so much for joining us. And as you probably know, we're going to do a few housekeeping announcements first, and then we'll get into the program. But enjoy the Dilbert cartoon as I'm going through this. So if you have already participated in our webinars, you can probably completely disconnect and ignore me and do whatever you need to do, eat your lunch while I go through this. But if you have not been on our webinars before, you should be seeing the PowerPoint in kind of the big bulk of your screen should be the PowerPoint, and then I am down here at the bottom right-hand corner. Hello. And you on the left, you will see a few icons, and you can see there is a little kind of thought bubble with a question mark in it. That is where you go if you have questions and you want to type them in. I will save all questions for the end. We have a lot of material to go through today. So I hope we have enough time to get to them, but if not, you'll see my email address at the end, so you can always email me. But we're going to try and save some room for questions. But like I said, if you have any, just type them in and where the question mark is. You will get 1 CMCA credit for this class. It will be emailed to you within the next 48 hours. And also with this particular class, you did not receive a copy of the PowerPoint. And the reason is because we are testing your knowledge, and we're going to have some questions and see how well you guys do. So I can't give you those ahead of time. But with your credit, you will get a copy of the PowerPoint with the correct answers on there marked. Finally, if you are having any technical difficulties, please don't type anything into that question mark category because I cannot help you with it. I know nothing about IT. Instead, what you need to do is email education@altitude.law or call Sean, our education coordinator. His direct office number is 303-991-2076, and hopefully Sean can help you with whatever the problems are. And then one thing to keep in mind, next week, I'm doing a webinar on using your experts. And that is going to be our last webinar of 2021. So, oh my gosh, we are on our way to 2022. And the education calendar is already up on our website if you want to go take a look at next year's offerings. But next week is going to be the last one of the year. So join us if you can, or if you want to. So at this point, I'll let you guys read this. For those of you who've been to my test your knowledge type classes in the past, you probably know what I do is divide you guys up into teams and give you really silly names for each of the teams with managers. And then we go to each team and you answer questions, and at the end, whoever has, the most points wins. So we're going to do the same thing today. I obviously can't give you team names, and this is going to be on an individual basis, but we're using the honor system. Keep track of how many questions you answer correctly. And I don't have a prize because I'm virtual, but I can send you like a virtual hug if you win, okay? Let's do it that way. So let's start. Like I said, we have a lot of questions to go through, so feel free to type in your questions as we go. All right. Oh, and enjoy the silly pictures. Allocated interests in a condominium community include the following: square footage of the condominium, undivided interest in the common elements, amenity usage rights, number of votes, A and B, B and D, or none of the above. This is a made-up term. Well, I am going to go through fairly quickly. The answer is dun, 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 F. Okay, B and D. So it's undivided interest in the common elements, as well as the number of votes. It also includes, even though it's not in here, allocation of assessments and how those are assessed, whether they're equal or based on, a percentage. So those are the three elements of allocated interests. In a condominium community, the common elements are owned by the association, the board, the owners, the manager, or the attorneys. All right, I'm pretty sure this is a quick one. So in a condominium, the common elements are owned, C, by the owners. They are owned as tenants in common by the homeowners. The association does not actually own the common elements, even though it has a legal obligation to maintain them. It does not own them, as opposed to a planned development such as townhomes, single-family homes. In those cases, the association does own the common areas, and there's actually deeds out there transferring those common areas to the association. All right. Which of the below actions creates a common interest community? Is it filing articles of incorporation with the Secretary of State? Filing the bylaws with the Secretary of State? Recording the declaration with the county? All of the above actions must be taken to create the community. The sheer will of the developer is enough to create the community. So I wish I could have like some background music playing while you guys think about this. But the answer in this one is C, recording the declaration with the county. That's what creates the common interest community. A lot of people go with A, filing articles of incorporation. If you went with A, it's incorrect because you file articles of incorporation to create the corporation. And to create the common interest community, Kiowa requires that you record the declaration and the map with the county. Okay, so the answer is C on this one. And of course, bylaws, they don't get filed anywhere. They shouldn't be filed with the Secretary of State. All right. The difference between a planned development and a condominium development is whether an owner owns land or airspace, the maintenance obligations, how assessments are calculated, whether the units have balconies, and the name of the community. So the answer is going to be A, whether the owner owns land or air. Remember, a planned development is a community where the homeowner owns a lot. If you see reference to the word lot in the declaration, that's a pretty good indicator that you're working with a planned development. And there's a lot of implications that go with that. But essentially, when you have a lot that's owned, a lot of times the association still maintains it. Like if you have a townhome, for example, the homeowner actually owns that structure, but the association normally maintains it. Why? Because usually that's what the declaration requires. And if you think about it, it makes sense because everything's connected, so it kind of keeps the continuity and the quality of the maintenance and the aesthetics of the community the same. Otherwise, you can have different people doing different things, and it could look pretty weird. All right. Which is true about reserved declarant rights? They expire 20 years after recording of the declaration. They allow a developer to amend the declaration anytime while the developer owns property in the community. They must be spelled out in the declaration or they don't exist. There is no such thing as reserved declarant rights. They are a figment of your imagination, could be, or A and B. So the answer is C. They have to be spelled out in the declaration or they don't exist. A lot of you probably thought the 20 years after recording, and although it's fairly typical to see that, the expiration of the reserved declarant rights is whatever the declaration sets it at. Kiowa doesn't set it at anything. No law sets it at anything. So 20 years is not the correct answer. That the developer can amend the declaration at any time, that also is not a correct answer because that is not in any statute, and that is not something that is inherently belongs, to the developer. Plus, once the developer sells lots or units in the community, the homeowner approval requirement does come in at that point. So Kiowa does say that the developer reserved rights must be in the declaration. So if they're not in there, they don't exist. All right? And then they are a figment of your imagination. Which of the below statements is true? Common elements get taxed like other property. Common elements are not taxed. If an association does not pay taxes for common elements, a tax lien may be recorded. Associations do not pay taxes on common area tracts. Owners pay taxes on common area tracts, or D and E. This is a confusing one. I get it. I know. So the answer is F. It's D and E. So let me explain that. According to Kiowa, association does not pay taxes on common elements. Okay. However, if you really think the government is going to allow a tax opportunity to go unclaimed, you're very wrong. Of course, the government does want its property taxes. So what happens with common area in an HOA? Well, it's still assessed a value, and there are still taxes associated with it, but those taxes get spread out among all the owners in the community. Okay, so what happens is part of each homeowner's tax payment, their property tax payment, includes a little bit of the taxes on the common area tract. If you, as a community manager, as a board member, if you're getting statements to pay taxes on common area, that should be a red flag for you, and you absolutely should get with the community's attorney to figure out what's going on. There should not be individual tax statements going out to anyone for the common area tract. So usually it's a sign of something bigger. Usually it means the tract was never transferred officially by the developer to the association, which requires some action on the part of the association to get that fixed. So definitely reach out to your legal counsel if you are getting tax statements. Oh, my favorite. That is horrible advice. All right. An emergency service vehicle is protected when it has an official emblem, weighs 10,000 pounds or less, is part of a volunteer fire department, the vehicle owner pays the association some money on the side, B and C, A, B, and C. I think this one's pretty easy. Hopefully you guys all got F. It's all of the first three items. So that's when a vehicle is protected. Now, these aren't the only facts. Obviously, it could be a police vehicle. It could be a health vehicle, but I mean, probably not, because 10,000 pounds or less, that usually does not include an ambulance. Those are usually more than 10,000 pounds. All right. Which of the below signs can associations prohibit? Now, keep in mind our new laws, right? Social messaging signs, signs containing offensive language, political signs, garage sale signs, signs that support non-Colorado athletic teams, or none of the above may be prohibited. Okay, so the answer is D, garage sale signs. Why? Because the one exception to content-based regulation is that the association can prohibit commercial signage. And of course, you want to define how you define commercial signage, but usually it's anything to do with commerce, sale, advertising a service or a product. And so garage sale signs do typically fall under that category, which means the associations can regulate them or prohibit them. All right. Energy efficiency. An energy efficiency measure includes all of the below except what? Swamp cooler, energy efficient outdoor lighting, air conditioners, retractable clotheslines, shade structures marketed for energy reduction. Answer is C. An air conditioner does nothing to help us save on energy or produce efficiency of energy. It sucks energy, and inherently we all know that, but for some reason, when I have this question, it doesn't always register that air conditioners don't belong in this group, but they most certainly don't. They are not energy efficiency measures. All right. A pre-Kiowa community can become subject to Kiowa if it does what? Fully rewrites its governing documents, obtains approval from owners representing at least 67% of all the votes in the association, obtains unanimous board approval, or obtains approval from owners representing at least 67% of the owners who are present at a meeting. Okay. So the answer is D. The answer is D. It actually takes less homeowner approval to opt into Kiowa than it does to amend your declaration. Now, a lot of people think that when you have a pre-Kiowa community, pre-1992, and they completely amend and restate their declaration, so it's a brand new document, that they automatically come into the purview of Kiowa just as if they were created after 1992. But that is actually not the case. You actually have to have a separate vote on opting into the full Kiowa statute, and that is only 67% of the owners who are present. So, or 67% of the owners who are voting. Of course, you're going to need at least a quorum of homeowners voting or present, but it's 67% of those folks. So it's a lot easier to opt into Kiowa. We don't see it a lot because if you're a pre-Kiowa community, why would you opt into Kiowa? It just means taking on additional obligations you don't currently have. It's not a whole lot of benefit of opting into it. So it's just more obligations, which is why you don't usually see pre-92 communities deciding to opt into Kiowa. I love this picture. I don't know what that hippo's doing, but I think it's so funny. Now you guys know how, this is what entertains Alina. Kiowa defines unit boundaries of a condominium when the declaration is not clear. According to Kiowa, which of the below constitute limited common elements? Exterior doors, roofs, windows, interior unit fixtures, A and B, or A and C? So the answer is F. It's exterior doors and windows. That is how Kiowa defines them. Of course, keep in mind, if you have a declaration that defines the unit as including windows and the doors, then those are going to be part of the unit in that case. This is only a definition we can adopt when your declaration is not clear and just defines it as the perimeter finished surfaces, in which case we don't really know what that means. All right. All right, true or false? A developer may not draft a declaration that uses a formula for calculating assessments that would require the developer to pay less than other owners. Is that true or false? So it's true, but developers get around this quite easily nowadays. So basically, Kiowa says, developer, when you're drafting your declaration for a community, you can't say, I'm the developer, therefore I pay less in assessments, or I don't have to pay assessments because I'm the developer. So what do the developers do? And I'm sure you guys have seen this over and over again, but you will see language along the lines of, until a certificate of occupancy is issued, this lot or this unit assessment rate will be half. Well, guess what? That's a developer-owned lot or unit. And once the certificate of occupancy is issued, it gets transferred to the homeowner, right? So, and then the full assessment comes on. So that's a way that developers get around that particular prohibition in Kiowa, but that prohibition does exist. So if you ever see a new set of covenants or a post-1992 set of covenants, and it has language along the lines of the developer shall pay less assessments, or developer shall pay 50% of the regular assessments, with no other reasoning in there but for it being the developer. Red flag, check with the attorneys, because most likely that is not going to be enforceable. All right. Which of the below is not a permissible method for an association to accomplish its public disclosures? Sending disclosures via snail mail, personal delivery of disclosures, providing disclosures at the annual meeting, keeping a physical binder with all the information at the principal office, posting in the website as long as notice of the website address is sent to all owners by mail or email. So which one of these? Another kind of difficult question. The answer is actually C, providing disclosures at an annual meeting, because although you can provide them with personal delivery, you are not going to have 100% of your homeowners present at the annual meeting. And so therefore, that would not be an appropriate way to deliver the disclosures. So honestly, the disclosures, the provision in Kiowa is confusing and misleading. It implies there's an affirmative duty on the part of the association to send forth these disclosures, but that's not actually what it says. I mean, you can send them. You can send them by snail mail, and you can personally deliver them. However, you can also have them in a physical binder at a principal office, so the management company usually, or you can be posting them on the website as long as you send something out once a year saying, hey, the disclosures are all on the website. Here's the website address. So there isn't necessarily the need to go out and deliver these documents to people. It's an option, certainly, but there's other ways of doing it. Yes. Who uses Facebook anymore anyway? I'm being told that Facebook's not it anymore. Apparently TikTok is it. So I don't know anything about TikTok other than what my kid tells me. All right. Which of the below is not a required good governance policy? Okay, this should be easy, right? Investment of reserve funds, policy on adopting policies, conflict of interest policies, insurance deductible policy, enforcement policy, a reserve study policy. It is D, the insurance deductible policy. It is a highly, highly recommended policy, but it is not a required policy under Kiowa. When it comes to collection efforts, which of the below statements is true? A payment plan must be offered to an owner every time he or she is delinquent. An association may not commence a collection action unless the delinquency equals 6 months of assessments. A lien must be recorded before a collection action may be filed, or a collection action cannot be commenced if the association has not adopted a collection policy in accordance with Kiowa. All right, so the answer is D. Kiowa specifically says if you don't have a policy that has all this stuff in it, you cannot enforce, you cannot collect. So the payment plan would be right, except that it's not every time someone is delinquent. Under Kiowa, it says you only really have to offer it once. However, I think most of the collection policies out there do offer it every single time, because it's going to be really difficult to keep track over the years of who has been offered a payment plan and who has not. It is just easier, and best practices would dictate that you just do it every time. The 6 months amount, that's only for starting a foreclosure. That's not to commence a collection action. Recording a lien, that's not a requirement either. You technically have a statutory lien by virtue of recording the declaration. And so there's no need to file this piece of paper, but we do. And the reason we do is because people are clumsy and people make mistakes. And if you don't have that extra piece of paper recorded, you never know if a title company is going to miss something. So it's basically us not trusting that everyone's going to be doing their job the right way. Another true or false. Associations are required to provide owners with education on an annual basis addressing general operations of the association and rights and responsibilities of owners and the executive board. The answer is true. It is, but Kiowa does not dictate, how you provide the education, whether it's an article, whether it's someone coming to your annual meeting and talking to the homeowners. I mean, it could be anything. So the options are pretty open. What is the minimum number of owners that must approve a declaration amendment? A majority of those who are voting, as long as a quorum is present, more than 50% of all owners, 51% of all owners. Whatever number is provided in the declaration, 67% of those who are voting, or 67% of all owners. All right, so the answer is B. Okay, it's more than 50% of all owners. The way Kiowa was written, it is more than 50%. 51% is more than 50%, but you can get approval that's somewhere between 50 and 51%, and that would be above the minimum. Okay, so it is a little bit of semantics here, but it's a simple majority. So 50% plus 1. If an association wants to utilize the court petition process to amend the declaration, it needs to obtain approval from at least 50% of all owners, 67% of the owners, half of whatever the declaration requires, 2 attorneys, or 1/3 of the community. So the answer is C. It's half of whatever the declaration requires. So let's say you have a deck that says you need 90% of homeowners to approve. If you get 45% of the homeowners approving, you have enough to petition the court. Although the 90% is lowered to 67% if you're just trying to get homeowner approval without petitioning the court. I know it's confusing. All right. If an association wants to utilize the court petition process, it cannot change the amendment requirement, change the allocated interest, change the insurance requirements, change any language impacting the declarant, change the language impacting first mortgagees, or do anything to upset the judge, because judges can be finicky. All right, F is probably true, but as far as Kiowa is concerned, it is B. You cannot change the allocated interest. And remember earlier we talked about what allocated interests are. They are the number of votes, how assessments are allocated, and your interest in the common area for a condominium community. So that is the answer in this case. All right. Before an association can utilize the court petition process, it must have done which of the below? Held at least 2 meetings with the owners to discuss the amendment, created a summary of all the revisions being suggested by the amendment, consulted with an attorney, sent at least 2 written notices of the amendment to the owners, or begged and pleaded with the owners. I think E is a given no matter what you do, but the real answer is going to be D. You got to do at least 2 written notices of the amendment to homeowners. The meetings one would be right if it was 1 meeting. You have to have at least one meeting, not 2 meetings. Okay, you don't, although a summary of the revisions is definitely a good thing to do, it's not a requirement, nor is consultation with an attorney, although again, certainly we would not recommend trying to draft amendments without an attorney's involvement. Oh, I like this one. The shark was not going to help him. All right, true or false? Per Kiowa, unless prohibited by the declaration, a board has authority to adopt rules, enter into contracts, impose late charges for delinquent assessments, and evict delinquent owners. True or false? So this one's false, and it's false for one reason. And the reason is There's nothing in Kiowa allowing associations to evict delinquent owners, right? Homeowners own their property and the association has no right to evict homeowners. All right. Pursuant to Kiowa, a committee chair must meet the same qualifications as required to become a board member. This is actually true. So if your documents say you need to be a record owner of a unit to be on the board, you need to be a record owner of a unit to be the chair of a committee as well. Kiowa requires a financial audit to be performed when? Is it when required by the governing documents, requested by 1/3 of the owners, total annual revenues and expenditures exceed $250 and 1/3 of the owner's request, A or B, or A and C? Okay, so the answer is A and C, or C, it's E. Okay, so basically if your governing documents require it, you got to do it. If you have total annual expenditures or revenue of $250,000 or more and 1/3 of the owner's request, you got to do it. B, if 1/3 request, that is only for a financial review. That is not for an audit. All right. The Kiowa budget ratification process deems a budget ratified unless a majority of all owners veto the budget. 67% of all owners veto the budget. A majority of a quorum of owners veto the budget. 67% of a quorum of owners veto the budget. The community manager vetoes the budget, or the homeowners get angry and throw sharp objects at the board members. Right, so the answer is A, a majority of all owners veto the budget. However, Kiowa also says it's that or any higher requirement that your declaration may have. So if your declaration says you need 90% of your homeowners to veto a budget, then that's what you're going with. However, the default is a majority of all. And for those of you who maybe said 67%, that seems to be what most people think. And maybe you're thinking just of the declaration amendment provisions in Kiowa, but it's actually a majority when it comes to the budget. True or false? Regardless of the Kiowa budget ratification process, a declaration may still require owner approval for a budget as opposed to a ratification. So that is true. Even if you're a community created in 2019, if your declaration says you have to get approval every year for the new budget, you are going to have to get approval every year for the new budget, and you can't use the ratification process. So that is absolutely true. In a post-Kiowa community, the vote to remove a board member cannot exceed owners representing 67% of all the votes. Owners representing 67% of those who are voting, as long as a quorum of owners is present. Owners representing a majority of all the votes. Owners representing a majority of those voting, as long as a quorum is present. There is no cap. Whatever is required by the documents must be followed. Okay, so the answer is going to be B. Okay, it's owners representing 67% of those who are voting, as long as we have a quorum of owners voting. So if you have documents that require something higher than that, and the community was created after July 1, 1992, that requirement is void, and it's 67% of those who are voting. All right. According to Kiowa, which of the below provisions must be contained in the bylaws? Number of directors, qualification of directors, which board powers may be delegated, which officers are authorized to execute amendments to the declaration. None of these. Kiowa does not contain requirements for content of bylaws. A and B only, or A, B, C, and D. Holy cow. The answer is actually G, and this is a hard one. But it is G. All of those, A, B, C, and D, Kiowa does require that information to be contained in the bylaws. Right. True or false? Kiowa specifically requires associations to maintain common elements and owners to maintain their units except as may be provided by the declarations. Is that a true or false statement? It's actually a true statement. Kiowa does have that language. So if you are fighting with homeowners as far as, you know, who you can't make me maintain my unit, well, guess what? We can. Kiowa says we can, even if the declaration doesn't. What the frog? Another true and false. Kiowa specifically authorizes entry into a private unit as reasonably necessary to perform maintenance, repair, and replacement of common elements. Is this true or is this false? It's actually true. This is a provision that I don't think most people ever refer to or talk about, but there is a provision along these lines in Kiowa and it authorizes it. This is a condominium. I don't think it definitely wouldn't apply to a single family home. I don't think it would apply to a townhome because you're not going to have usually common elements in a townhome, but it could. So that provision is in Kiowa, folks. Kiowa caps the number of owners required to petition the board for a special membership meeting to majority of all owners, 10% of all owners, 20% of all owners. There is no cap. This is a trick question, which I would never do, or 25% of all owners. So the answer is C. If so, a post-Kiowa community actually doesn't matter. Any community, if you have a requirement that is more than 20% of all owners have to petition for a special meeting, it does go down to 20. Which of the below statements is true concerning notice of regular monthly board meetings? Notice must be provided to owners. Notice must be provided to the directors. No notice is required. Notice must be provided to the community manager, or notice must be provided to committee members. So the answer is C. For regular board meetings, whether they're monthly or quarterly, whatever, if they're the regular scheduled meetings, no notice is required for anybody. At a board meeting, owners must be allowed to speak when? Before the board votes on an issue? Never. Owners are too disruptive and dumb. Only during open forum. Anytime the owner wants to speak, or if so provided on the agenda. They must be allowed to speak before the board votes on any issue, and hopefully everyone is well aware of this one, because this has been around for a while. The board can go into executive session for any of the below reasons except what? To discuss a legal opinion, to discuss a criminal investigation, employment issues, staff salaries, contract for legal services. Or boards should never go into executive session, as nosy owners are entitled to know everything. Wow. So the answer is E, the contract for legal services. That is not an attorney-client privileged communication, and so it does not fall under any reason that Kiowa provides for going into executive session. True or false? When it comes to owners speaking in front of the board prior to a vote, the board must allow at least 3 people to speak before it votes. So the answer is false on that one. Kiowa says you have to allow a reasonable number of persons on both sides of the issue. It doesn't say 3, so that's not correct. True or false? Proxies must be allowed during membership meetings regardless of what the governing documents state. That is true, okay? So if any of you are out there telling your homeowners you can't bring a proxy, you can only attend in person, that's a big no-no. Stop doing that. You have to allow proxy attendance. That does not mean you have to provide a proxy form, but you have to accept proxies. Okay, that's all that means. And of course, this is my mantra right there. All right. Which of the below statement is true with respect to proxies? Owners must utilize the association provided proxy form for their proxies to be valid. Proxies must be dated. A proxy must designate a proxy holder. Proxies cannot be for a period greater than 11 months, and proxies promote laziness and should never be used. Okay, so the only statement that's true is B. Proxies have to be dated. They don't have to designate a proxy holder because they can be for quorum purposes only. They can be for a period greater than 11 months. What the statute says is, unless otherwise specified, a proxy is good for 11 months. So you can have proxies that last longer than that. Promoting laziness, I'm not even going to comment on that one. All right. What is required for a post-Kiowa community to transfer common elements? Unanimous board approval, whatever is required in the declaration, approval from at least 67% of all the owners, approval from a majority of all owners, or post-Kiowa communities are prohibited from conveying common elements. All right. It's C, it's approval from at least 67% of all the homeowners. Okay. And there's no ifs, ands, or buts about it. If you are a post-Kiowa community, it doesn't matter what your declaration says. It's 67%, unless you have a higher requirement for approval, in which case follow that. But according to Kiowa, 67%, that's the floor. Which of the below statements is true about a unit owned by a post-Kiowa association? The unit cannot vote. The unit is exempt from paying assessments. The unit cannot be sold without owner approval. The unit must be used as an on-site manager suite or a guest suite. None of the above statements are true. One statement is true. It's A. Post-Kiowa communities, any association-owned units may not vote. And that is a fact. A post-Kiowa community is required to carry which of the below insurance coverages? Directors and officers liability, commercial general liability, umbrella, flood insurance, A and B, A, B, and C. So the answer is B. The only one of these policies that's required to be carried by an association is the commercial general liability, which is the liability policy. If somebody has a slip and fall, with the community. Directors and officers liability, you would think it would be required, but it is not, even though hopefully every single association has that policy. An umbrella policy is highly, highly recommended, but is not required. And a flood insurance policy is not required, except if you're in a FEMA flood zone, and that is a whole different analysis, okay? So B is the only one that is required, commercial general liability. A post-Kiowa condominium community must ensure which of the below items? Upgraded fixtures inside units, the condominium units themselves, all finished surfaces inside condominium units, appliances, window coverings inside the condominium units. The answer is B, it's the condominium units themselves, although we can exclude homeowner installed improvements and finished surfaces. Okay, so obviously we don't have to insure upgraded fixtures. We don't have to insure finished surfaces or appliances. But the condominium unit itself would include obviously the drywall, the subflooring, any originally installed fixtures. That would all be part, the windows, the doors, those would all be included. It's something the association has to ensure, whether your declaration says it or not. For a post-Kiowa community, you are required to insure the condominium unit. True or false? Pursuant to Kiowa, Insurance proceeds must first be used to pay for repairs and restoration and cannot be turned over to owners unless there is a surplus. That is true, my friends. You cannot turn over insurance proceeds to homeowners. This is only for post-Kiowa communities, so pre-1992, hypothetically, you can do it. Post-1992, no way, you can't do it. Okay? So keep that in mind. That means the insurance funds that are received by an association have to go to pay the contractors directly, or you got to figure something else out because you're not going to give that money to the homeowner and say, go get your own contractor. Or you can tell them to get their own contractor, but then submit the invoices to the association, and then we will write a check for our portion. True or false? Kiowa requires Kiowa requires associations to pay deductibles for any losses that are adjusted with the association's insurance policy. That is actually false. It does not specifically say that. However, please keep in mind there is some general language that implies that unless an association has an insurance deductible policy to the contrary, that the association should be paying these deductibles associated with claims it submits. So if you have a post-Kiowa community, you're either on the board or you manage it, please make sure you have an insurance deductible policy in place. And I think most of the insurance brokers are preaching this as well. You need to have one so that the deductible isn't allocated against the association. All right. Which of the below is not an accurate statement under Kiowa? Every unit owner must be an additional insured under the association's policy. The insurer must waive its right to go after the owner for damages, even if the owner was negligent. The insurer cannot accept claims filed by owners. Property insurance must cover improvements for full insurable replacement costs. Which of these is not a true statement? The answer is C. That insurer cannot accept claims filed by owners. They, in fact, are required to under Kiowa to accept such claims because homeowners are supposed to be additional insureds, which means it's their policy. Now, I know for a fact that realistically that does not happen. A lot of times you have boards that reach out to the brokers saying don't accept claims from homeowners, and the brokers say, okay, we won't, and they don't. However, legally, they really should be accepting them because homeowners are an additional insured under the association's policy and have every right to submit a claim, just like the association does. So, just an FYI. And perhaps my favorite meme of the day. Indeed. All right. What is the cap that may be imposed against delinquent accounts as set forth in Kiowa? Is it 21% per annum, 18, 8? Kiowa does not actually impose a cap. Whatever the declaration provides is fine. Our owners should be charged as much as possible so they stop being slackers and start paying their assessments. I know you all want to say F. But Kiowa sets a cap of 21%, and that's A. So this is for post-Kiowa communities only. If you have a pre-Kiowa community and there's a higher percentage set, technically that doesn't violate the statute, but it still could be subject to usury claims. So make sure that you have your attorney look at that. Anything over 21%, usually raises some red flags, at least in my head. Which of the below records are prohibited from being disclosed to homeowners? Is it attorney communications, contract bids, board members' email addresses, owners' email addresses and phone numbers, executive session records, A and B, or all of the above? If you said G, all of the above, you have fallen for my vicious scheme to trick you because that's not the answer. The answer is D. All these other things on here, the board has discretion to disclose. They have the option of not disclosing it, but they're not required to keep it from being disclosed. Owners' email addresses and phone numbers must not be disclosed unless each homeowner approves in writing of the disclosure of that information. If I had an alpaca, stick its head out the window and stare at me, I would take pictures of it too. I think it's amazing. All right. Which of the below records must be made available to owners upon requests? Ballots and proxies, physical mailing addresses of directors, records of amounts received from construction defect settlements, all of the above, or none of the above? The answer is D. All of the above must be made available to homeowners who requested it. All right. True or false? Unless specifically prohibited in the documents, the Nonprofit Act allows boards to amend their community's bylaws. So that is true. That is true. And there's certain caveats with it. But generally, you can amend your bylaws as a board. However, like I said, don't just go and amend. Talk to the attorney. There are certain things you cannot amend without homeowner approval. A post-Kiowa association board may not unilaterally amend the bylaws to change what? Let's get into those exceptions now. What can't we amend as a board? Number of directors, fiscal year, director terms, annual meeting date. The board can change anything it wants in the bylaws, and owners don't have any say because they are peasants. I know what you want the answer to be. The answer is C. That's one of the things a post-Kiowa community cannot amend. Director terms. So if you want to go from 2-year to 3-year terms, got to have homeowner approval for that kind of a change. A solicitation for vote by mail ballot must contain what information? Number of votes needed for the measure to pass. Deadline for receiving the votes. Quorum requirement, even if quorum is irrelevant to the vote. All of the above or only A and B? The answer is D, all of the above. So if you're ever trying to send out your own mail ballots without consulting with legal counsel, I encourage you to consult with legal counsel, because if you're missing anything, it's not going to be a valid vote. But please make sure those 3 things at least are in there so that, the vote hopefully is valid. True or false? Unless otherwise provided in the bylaws, a written ballot may not be revoked once cast. That is absolutely true. Okay? And most bylaws do not say anything about it. So keep in mind that it's different than a proxy when you're actually voting by mail, okay? Because proxies can be revoked, mail ballots usually cannot. True or false? When conducting a vote by mail ballot, it is advisable to use proxies. Okay, that's a big, huge false, because proxies are never going to be used in conjunction with a mail ballot. Okay, proxies are only used when you're holding a meeting. When you're voting by mail, you're taking an action outside of a meeting, and so you're not going to use proxies. Or Firefox. All right. Which of the below statements is true? I think we're going to finish here in just the next couple of minutes. Associations are required to prepare an alphabetical list of members who are entitled to notice and to vote at a meeting prior to sending notice of a meeting. The owner list must provide each owner's address and number of votes the owner has. The list is subject to inspection by owners. All of the above are only A and C, and the answer is D. All of the above are true. If you're not doing this, you may want to consult with the association's legal counsel so that they can give you advice on what this all means. According to the Nonprofit Act, an officer on the board must meet which of the below qualifications? Be an owner in the community, must be at least 18 years of age, must be a resident in the community, must be in good standing, must be liked by the rest of the board. So the answer is B, they have to be over 18. That's just to be an officer, not to be on the board necessarily. There's no age requirement to serve on the board in the Nonprofit Act. So hopefully there's requirements in the bylaws. True or false? The Nonprofit Act requires director terms to be staggered. That's false. That requirement is contained in the Condominium Act, and a lot of it has been overridden, but it does still apply to pre-Kiowa condominium communities, the requirement for staggered terms. True or false? A director being appointed to fill a vacancy on the board does so until the next annual meeting. Okay, that's false. Directors fill the vacancy until the end of that term, whether it's the next annual meeting or whether it's in 2 years. When you appoint to fill a vacancy, it's always going to be for the remainder of that term. Brave chicken. In order to resign from the board, a director must submit the resignation in writing, be allowed to step down by the rest of the board, say please, clearly state his intention to resign at a meeting so this decision may be documented in the minutes. Board members are not allowed to resign ever. All right, so the answer is A. You actually have to resign in writing. If you don't, if you do it verbally, it's not technically legally a resignation and you are still on the board. All right. Which of the below is a standard of conduct imposed on directors by the Nonprofit Act? The duty to attend meetings, the duty to act with the care of an ordinarily prudent person, the duty to be good looking, the duty to never be wrong, A and B, or A, B, and D. The answer is B. That is the only one that is actually required by the Nonprofit Act. If the bylaws and articles are silent as to the number of directors, the Nonprofit Act requires 3, at least 1, 5, 1 director for every 25 units, or 1 director for every 50 units. The answer is B, at least 1 director. Now, it is 12:57. I have 3 minutes. I am going to see if I can answer a couple questions. Facebook is now called Meta. I heard that. Alina, for an annual or budget meeting, is the notice mailed with the incorrect date on it? Does an entire new notice need to be mailed, or can an email to owners be sent out and have signs posted? My recommendation would be, if it's more than 10 days before the meeting, just mail a brand new notice so there is no challenge, or the meeting is not subject to challenge. If it's less than 10 days, I would probably reschedule the meeting and mail out all new notices as well, but you do have to change the meeting date at that point. That would be my recommendation. Otherwise, the meeting will be subject to challenge. Regarding the question about allowing owners to speak before a vote is taken by the board at a meeting, do we have to ask owners if they have questions before every vote taken at a meeting, or can we simply announce this at the beginning of the meeting and let homeowners speak up when they have a question? No, you actually, the way Kiowa's written, you actually have to allow, before you vote, you got to look out to the audience and say, does anyone have any comments? And then allow comments, a reasonable number of comments at that point if anyone has any. So you do have to do it before every single vote, unfortunately. All right, you know what? I think that's all the questions. Oh, wait, sorry, one more. An annual meeting, if no quorum is present and you have 3 members wanting to be on the board, 2 board members resign, do you send out a mail ballot? If you don't have quorum, I would recommend you either try calling the meeting again to have the vote, or try to do the election by a mail ballot. YouTube, this will be on YouTube. We are going to have this on YouTube in the near future. Board member submits a resignation. Can they withdraw and still stay on the board? Technically, once you've submitted it, you've submitted it. It depends if you say effective immediately. If you say effective immediately, no, the board would have to reappoint you back to your old position. If you say, you know, effective tomorrow morning and it's not tomorrow morning yet, then I would say yes, you probably can take it back at that point. All right, we're at 1 o'clock, everyone. So thank you so much for joining me. I hope a lot of you will come next week for our last 2021 presentation, and we will see you next time. Thanks so much, guys.